Today at heads of terms for a new lease, and we're going to do a quick brief walkthrough guide mainly aimed at businesses that are just starting up or new. So a little bit more about Harrington Carmichael. As a law firm, we're a full service law firm. We have clients based both here in the UK and overseas, and we act for all sizes of businesses, all values of businesses across all sectors. And a little bit more about Wise itself. We set up Wise, Wednesday Insights for Startups and Entrepreneurs, alongside our free workspace that we offer to business startups in our offices. So businesses that are just starting up, or individuals that are wanting to kind of kickstart their business, can come into our premises for free, benefit from using the services that are on offer. And then these sort of legal webinars sit alongside that service that's offered, and we are pitching them at different aspects of advice for startups. Today's obviously focusing on the property elements. So if you're a new business or an individual and you're doing well and you're thinking of maybe expanding, taking on premises, maybe a new office, or if you're manufacturing, you might want to take some industrial premises. At that stage, you would be looking at negotiating what's called heads of terms, and that's what this webinar is about.
Thank you, Rachel. Also, just a brief introduction to who we are. So Rachel, who just spoke, Rachel Duncan is a partner and our head of landlord and tenant in our commercial property team. Myself, Hayley Moore, a legal director, also in the commercial property team. And you'll find our contact details also at the end of the slides. So in today's session, what we are going to cover is a look at the heads of terms, specifically what are they, why the heads of terms are important, and key heads of terms to consider and what to watch out for. So heads of terms are used in a variety of matters. They are typically ones that are transactional in nature. You'll find them in commercial and corporate matters, but specifically we're looking at the heads of terms in a property transaction and focusing today in this session in a commercial lease transaction. Just for those of you that don't know, what is a commercial lease? A commercial lease is a form of legally binding contract that's made between a business tenant and a landlord. The lease provides a tenant with a right to use property for business or commercial activity for a set period of time, which is known as the lease term. In return, the tenant will pay rent to the landlord, and the lease will also outline the rights and responsibilities of both the landlord and tenant during the lease term. There are two main parties to a commercial lease: the landlord, sometimes known as the lessor, and the tenant, sometimes known as the lessee. In some cases, you will find a guarantor, which is typically at the landlord's request, and this is a person who agrees to pay for any losses that arise because the tenant has breached the lease or is unable to pay its rent. And quickly, just looking at the difference between residential and commercial lease, because in this session we are focusing on heads of terms for the commercial lease only. Residential properties are obviously used for residential purposes, for example, private habitation, and will include houses, flats, bungalows, etc., while commercial properties will serve business purposes like offices, stores, warehouses, showrooms. There is less governmental protection in place for commercial property tenants. It is understood that if you are taking on a commercial property lease, you should be more knowledgeable about running a business and therefore the resulting liabilities that occur under the lease than, for instance, someone renting their first apartment. So there is more room for negotiation in a commercial lease transaction. Again, both parties are typically considered to have more knowledge of business practices, and this is why we lead on to the heads of terms. So heads of terms, what are they? They create a structure for the transaction, and they provide an expression of intent between the landlord and tenant. There isn't a particular format. They're usually either a table or a bullet point of terms, typically 2 to 3 pages long, and they cover the agreed position regarding certain universal lease clauses, so the main provisions that you'll find in a lease. This will include things like rent, repairing obligations, break rights, tenants' ability to assign or sublet, alterations, and so on, which we'll look at in the succeeding slides. The heads of terms are not legally binding in themselves, but they can be used later down the line by the lawyers when arguing their position over the content of the lease and any other legal documents.
Thanks, Hayley. So taking each of the heads of terms that you might expect to see one by one, let's look at annual rent. Now, obviously, this is quite fundamental to both the landlord and the tenant. So you would expect the heads of terms to expressly set out what the starting annual rent is going to be for the lease. You'd also want it to include, if there's a rent-free period, how long that lasts for. Sometimes there might be a lower rent, like a half-yearly rent paid for a period of time. So all those kind of things need to be included in the heads of terms. And then that would obviously, of course, lead also to rent reviews. Are there going to be any rent reviews? If so, when are they to take place? And also, how are they taking place? Because there are different mechanisms that can be used to review a rent in a lease. The usual two methods would be either an open market review, or alternatively, sometimes the rent can be index reviewed in line with inflation. And these are two different types of rent reviews. And again, this could be discussed with your agent who's advising you on the heads of terms as to what would be best for you in the market at the given moment in time. Another point to note is that you may or may not have to pay VAT on the lease rents. So the figure that's stated in the heads of terms will be usually exclusive of VAT. So you need to know, if you're a tenant, whether your landlord has opted the property for VAT or not, and therefore whether you will have to pay VAT on top of that amount on the lease rents. The way it works is that a landlord has to expressly opt a property for VAT by submitting paperwork to HMRC. And once the property is elected for VAT, then a tenant has to pay the VAT. So a question as a tenant would be, has my landlord elected the property? And it's good to know that really early on, because obviously you'll know how much the rents are going to be. Similarly, interest, is there penalty interest on late payments under the lease? If so, how long till that kicks in after the late payment? And what is the likely penalty rate going to be?
Yeah, and also just a brief point to note on the annual rent. As Rachel mentioned, it would be the surveyor or agent who would engage at the outset. So the agent or surveyor will negotiate between the parties what the annual rent is. And typically once that has been agreed and you have a set of heads of terms, which we also look at later, you would also want to seek legal input at that point. From a tenant's perspective, for example, is there any rent-free period? If, for example, the tenant is carrying out some fit-out works, and those fit-out works are likely to take between 3 and 6 months, but we don't see a rent-free period in the heads of terms, we can advise the tenant that that would be typical in the market and something that they might want to push for. The agent will typically obviously stand behind the tenant and push for some things, but obviously they are also acting for the landlord, and therefore we can assist with matters that the agent might otherwise not point out.
It's also worth mentioning on the annual rent point that we quite often as property lawyers get asked by our clients, is this an acceptable level of rent? Is this about right for what I should be paying for the premises? Unfortunately, we cannot give any valuation advice ourselves, which is why we always steer our clients towards using a property agent in terms of negotiating the heads of terms. An agent who's local to the area perhaps, or has expert knowledge in that geographic area for similar types of leases of similar properties will be able to give both sides a steer as to what's normal. If they're acting for the tenant, they can advise on what incentives would normally be offered in the market at that time. And so it's best to always engage with an agent. So another head of term that's important is the repairing obligation, and not just for the tenant. This applies to sort of landlord and tenant. There are different types of lease, and the first question is going to be, what is the extent of the demise of the lease? So basically, what property is going to fall under the tenant's responsibility? Is it the whole of the building, including the structural parts? So that could include roof, foundations, walls, or is it just going to be the internal parts only? So if, for example, you were taking a few suites in an office block, you would expect it to just be the internal parts of those rooms. So that would just be like the ceiling covers, the floor covers, carpets, and the wall coverings. So it's important for the tenant and the landlord to button down exactly where the division of responsibility lies. If it's internal only that the tenant is taking, then usually you would want, as a tenant, for there to be an obligation on the landlord to then cover the repairs of the full structure of the building. And the landlord would normally want to recharge that or a proportion of it back to the tenant via the service charge. So all of these things are important to kind of set out as early as possible. If a tenant is taking the whole of the premises, roof, foundations, walls, etc., then we would normally recommend from a tenant's perspective that they may want to limit their repairing obligation with a photographic schedule of condition. Now, this is just a document, literally what it says on the tin, a bunch of photos showing the property at the date that the lease is entered into or just shortly before. And it specifically highlights any existing areas of disrepair. So, you know, it might be cracks in the roof or it might be areas of damp on the walls. And basically the tenant then, their repairing obligation is limited so that they don't have to hand back the premises in any better repair than when they took it on. And this can save tenants a lot of money at the end of the lease, because leases traditionally are drafted that a tenant has to hand back in good and substantial repair and condition, regardless of the state of the property when they take it on. And this can come back to bite tenants quite often. So by limiting it with reference to photographic schedule, then the tenant has the peace of mind that they're not going to have to do any additional improvement works to the property. They just have to make sure that it doesn't deteriorate further during the lifespan of the lease.
Yeah, and on that point as well, for the tenants, going back to the heads of terms and drawing those up, the more detailed the heads of terms can be, the better it is in terms of the obligations to be set out in the lease. Looking at a tenant's perspective on the repairing obligation, if the heads of terms state that the tenant is to keep the property in good repair, and that wording is used in the lease, that actually implies an obligation on the tenant to also put it into good repair where it is not already. And so Rachel's reference, the schedule of condition, assists in terms of limiting the tenant's liability to the condition it is in at that date that the schedule of condition is carried out. But it's also important to engage a commercial building surveyor if you're concerned by the repairing obligations that you're taking on, because they are extensive. Both from a landlord and tenant's perspective, it needs to be made clear what those liabilities are, and from a tenant's perspective it can be very costly. You assume that you're just required to keep it in repair, but actually putting that property into repair where there are areas of disrepair can be very, very costly, particularly if you're taking on the roof and the structural elements, and therefore we would also advise a building commercial surveyor to get engaged on that transaction.
Okay, next head of term, break clauses. This is basically an ability for either party, sometimes both parties, to terminate the lease early. So obviously the lease will be granted for a fixed contractual term, and sometimes it will include a right, usually just for the tenant, but sometimes for both parties, to effectively bring the lease to an early end by serving written notice on the other party. This is called the break right or a break clause. So it's important, again, to button down the details of this into the heads of terms. The parties need to know, who has the right to break early. Is it tenant only? Is it mutual? Is it a one-off right on a fixed date at some point during the lease term? Or is it what's called a rolling break, which basically means that at any point after a particular date and time, the party can exercise the break. Also, from the tenant's perspective, it's really important to try to sort of make the conditions attached to a right to break as easy to comply with as possible, because this can often come back to bite tenants if a break clause is drafted in such a way that it's very difficult to actually comply with. then this can lead to a tenant not being able to exercise their break in the future. The way the courts have gone in recent years is to very strictly interpret break clauses and the wording that is used in leases, to the extent that a judge ruled in one verdict that, you know, if a break clause says that the break notice has to be served on blue toilet paper, then it needs to be served on blue toilet paper. So it was very much interpreted strictly as written, and so that's why the drafting of the break clause is really important from the lawyer's perspective. So we would want to see in heads of terms what conditions have to be complied with, and we would want to make these as easy for the tenant to comply with as possible.
Yeah, and the break clauses have changed significantly over recent years, owing to the fact of recent case law, which Rachel has already alluded to. There's also some particular cases on vacant possession, and the tenant being required to give vacant possession of the property before it can break the lease. And there's a case with tenant leaving behind some racking, other personal items like umbrellas, and the break can be then frustrated, which means that the right to terminate is no longer available to the tenant, and they remain on the hook under the lease because the condition has not been strictly complied with in terms of the vacant possession element, in order that the property has to be completely clear of all tenant items and possessions. And so again, when you're negotiating the provisions of the lease with the landlord and you think, well, that's fine, you know, all we have to do is vacate, seek early advice on the terms, and they should be strictly detailed or sufficiently detailed in the terms, and we can advise you where something might seemingly seem to be easy to comply with, where in reality it's not.
Thanks, Hayley. Next one, alienation. Now, this is a legal term, but basically just means the ability for the tenant to effectively get rid of the lease during the life of the lease. So this could be by transferring the lease to another tenant, or it could be perhaps by subletting the space. So this will become important. You know, as a tenant, you might not think it's important at the outset. You'll obviously be envisaging using your space for the full duration of the lease. But if your business changes, the situation changes, there may come a point in time where you do want to absolve yourself of the lease liability. You may want to transfer it to somebody else. You may want to sublet to generate more income. And so it's really important that the alienation provisions in a lease are beneficial to you as tenant for your future requirements. And so again, these kind of considerations need to be looked at right at the outset and buttoned into the heads of terms. So we would normally advise, if we were advising a tenant, we would be looking at how easy it would be to transfer or sublet, if there's any conditions that might be applied, whether there is any security that has to be given by yourself as tenant. For example, if you're transferring your lease to another tenant, quite often a landlord will ask for an authorised guarantee agreement, which we call an AGA. But this is basically you as outgoing tenant guaranteeing the performance of the incoming tenant for the tenant lease covenants. Now, if you're transferring the lease to a really, really strong, solid covenant, you know, financially strong company, then you might think, why should we be guaranteeing their performance of the lease? And you might not want to give an AGA. So things like this can be discussed, thought about, and ironed out at the heads of terms stage.
Yeah, and there's a balancing act, and obviously there's conflicting desires in respect of both the landlord and tenant here, as with many other terms. Obviously, the landlord is wanting some tighter control of the premises because, as Rachel has mentioned, if they've got a really strong tenant covenant, they don't then want the property to be assigned to a weaker covenant and risk, obviously, non-payment of rent. At the same time, the tenant wants the flexibility to be able to dispose of its interest in the lease should their plans change. And there's other matters to consider as well. For example, if there is a 10-year lease and there's very little alienation provisions, the tenant doesn't have the right to, say, assign the lease or sublet, that can actually negatively impact the rent review. And these are things that the lawyers can advise on that typically you wouldn't know when drawing up the heads of terms.
We would also look for, if we were acting for a tenant, we would also look for the lease to contain what's fairly standard these days, but an ability for a tenant to share occupation with an associated group company. Now, obviously, as a startup business or an individual starting out, you're probably not going to be thinking that, you know, such thing is applicable, but as your business grows, you may welcome in future years this ability to share the space with an associated company without having to seek consent from the landlord at a later date, because obviously there is a cost involved in having to get the consent further down the road. So if we can get that in the lease for you from the start, it's to your benefit. Similarly, alterations, it's important to know as early on as possible, really, what alterations the tenant is envisaging to carry out to the premises. And again, this will depend on what type of premises they're taking and the extent of the premises. So whether they're only taking the internal parts or whether they're taking the whole of a building or units. The usual accepted position in a lease would be that any internal non-structural alterations require landlord's consent, and any external or structural alterations are usually prohibited altogether. So if a tenant knows from the outset that they're likely to want to carry out external or structural alterations, it's really important to flag this right at the beginning so it can be built into the heads of terms and dealt with really early on. So we would want to button down what alterations can be carried out, whether consent is required for them from the landlord, and also fundamentally whether they need to be reinstated at the end of the term. A landlord would usually always expect an ability to require the tenant to have to remove any alterations and to make good the property, basically the tenant leaving it as it took it. But if a tenant is upgrading the property, for example, perhaps it might be installing electric vehicle charging hubs or other such sort of alterations that are going to have a really good impact on the property, then they may not want to have to reinstate those at the end of the term. And, you know, it doesn't make sense from a landlord's perspective either. And so that could be built into the heads of terms that these items don't have to be reinstated.
Yeah, and then looking again how this can impact on other provisions. If a tenant is carrying out extensive fit-out works and they are making significant and costly improvements, the tenant is not going to want to have those improvements what we call rentalised in terms of the rent review, i.e. they don't want to pay for those improvement works and then those improvement works also be reviewed in the rent review under the lease, and therefore the tenant is basically penalised twice in having to carry out the cost of them and then the rent being uplifted as a result of those improvement works being carried out. And again, we can advise you on the provisions to go in the heads of terms. There's other key considerations in terms of reinstatement as well. It can be very costly to a tenant if they're carrying out significant improvement works and then they are required to reinstate at the end of the term, despite the fact that it improves and modernises the building. That can be very costly. And also the flexibility for the landlord to be able to say to the tenant at the end of the term, we don't like what you've carried out, we've consented to it, but we actually want that removed. And so there's a balancing act between the landlord and the tenant again as to looking at their reinstatement obligations at the end of the term. These are all part of the discussions that will be had when drawing up heads of terms, although most of the time you're not going to have sufficient detail, and we can therefore advise you on the provisions if it's obviously not part of the heads of terms stage. But it's just something to consider when discussing alterations, that it's not just looking at what alterations can be carried out, but the knock-on effect of having certain provisions in the lease and what's going to happen at the end of the term.
Another point to consider on alterations, and this is somewhat of a hot potato topic at the moment, relates to the energy rating for the property. So obviously properties nowadays have an EPC rating, an energy performance certificate rating, and the last government brought in measures that mean that commercial buildings have a minimum energy rating standard that they have to comply with, and this is due to increase over the coming years. So under a lease, normally a tenant is obliged to comply with any statutory obligations in relation to the property. So if you're a tenant, it's really important to know what the energy rating of the building is when you take it on, and also therefore whether there are likely to have to be improvement works carried out during the lifespan of the lease that might mean that they're needed to the building to increase the building's energy performance certificate to the minimum rating. If your building that you're wanting to take is a low banding and doesn't have a good EPC rating, then it might be worth, as a tenant, broaching this with the landlord really early on, saying, look, if any works are needed during the life of the lease, then really you should be funding those, not me. And again, this could be written into the heads of terms. So it's just another point to consider, and it's quite topical at the moment.
Yeah, it is, and it's just worth noting as well for landlords that you can't currently let lawfully any premises that have an EPC rating which is below an E rating, and therefore for any transaction that you are letting the property on the open market, you do require an EPC in any event, but it's advisable to get one at an early stage, that you're aware of any improvement works that are required to bring that EPC up to the substandard rating, i.e. E or above. And therefore you can then negotiate in terms of the rent and other matters in the heads of terms, considerations as a result of costs that you might have otherwise unexpected in terms of the improvement works. So it should be sought at an early stage and then factored into the discussions and negotiation.
Okay, buildings insurance. Normal position would be in a lease that the landlord would insure the building. I mean, it's their asset, so they're going to want to retain that responsibility. And then they would normally recharge a fair proportion or the whole of the premium, in the case of a lease of the whole of a building, to the tenant. From a tenant's perspective, it's useful to know exactly what proportion they will have to pay from the outset if it's a shared building. A tenant also will be keen to know that, for example, if the property is destroyed or damaged by an insured risk and they can't actually occupy the property for a period of time, will their annual rent be suspended during that time? And also, would they be able to terminate the lease if the property isn't rebuilt within a certain period of time? All of these provisions will be found in a lease and can be set into the heads of terms. And there is a sort of general standard position, a standard sort of market common position that parties usually end up with. And so as a lawyer, we can look at the heads of terms and we can advise you if anything seems abnormal or non-market standard.
Yeah, and on the buildings insurance point as well, specifically looking at uninsured risks, which are typically found in a modern commercial lease, it is useful to also put in the heads of terms whether uninsured risks are going to be included and who's going to be responsible for any uninsured damage. So that's damage to a building that's not covered by an insurance policy. And it can be quite costly, obviously, to either party to have to repair damage that's not covered by an insurable risk, and therefore it's worthwhile just setting out whether the landlord or the tenant is taking responsibility for uninsured damage. And you would typically find, like with the insured position, that a landlord will agree to cover uninsured damage as a result of it having the freehold reversion and the interest in the building, and then a right for either the tenant or the landlord to terminate in the event that the building hasn't been repaired following uninsured damage, and the landlord having what we call an election notice to be able to opt to rebuild the property following uninsured damage if it chooses to do so, but can terminate if it is not reasonably practicable for the tenant, for the landlord to rebuild. And there are obviously more drafting provisions to consider, but it would be very wise to include in the heads of terms whether the landlord is taking responsibility for uninsured risks or for the parties to set out the position that's been agreed.
Important also to look at the service charge provisions that are going to take place in the lease. If a tenant's taking a lease of the whole of a building, then they might think, well, hang on a minute, there isn't going to be a service charge. But even then, you might get caught, because often a unit, for example, on an estate, there'll be an estate service charge payable, which will be passed on to you through the lease. So again, at the outset, try and find out from the agent as early as possible what service charges are likely to be incurred, or estate charges. Similarly, in the lease, there'll be a list of services that the landlord is obliged to provide and is able to recharge for. Now, often the lease is worded so that the landlord isn't actually obliged to provide the services, but just has to use, reasonable endeavours to do so. So from a tenant's perspective, if there's any particular service that they know they're going to need for the efficient running of their business, this could be, a water supply, it could be heating at a particular level, whatever it is again, very important that it goes into the heads of terms that the landlord will be obliged to provide this during the lease. So yeah, it's important to set out what services are able to be provided by the landlord, what services have to be provided, and what can be recharged via the service charge. From a tenant's perspective as well, if we're acting for a tenant, we'd quite often try to seek a service charge cap built into the heads of terms, which is really the only kind of fail-safe way of protecting the tenant from large service charge demands. Service charges often include an ability for a landlord to set up what's called a reserve fund or a sinking fund, which is basically a sort of slush fund of monies that can be used for unquantifiable services in the future if needed. And often this element of a service charge can be quite high. And so a tenant can often be asked to pay a service charge towards kind of items that it's not really sure what they are or why they're needed. So the only way to really protect yourself as a tenant is to ask for a service charge cap. This is an annual amount by which, the service charge level can't go higher than that. It usually increases each year in line with indexation. But it just basically gives you as a tenant peace of mind, security, that you won't have to pay above a certain level.
And the landlord should also note with the cap that whilst Rachel mentioned it is typically increased in line with indexation, i.e. RPI or CPI, it should be comfortable that despite the annual increases in line with inflation, that it's not going to be significantly out of pocket. Obviously, it's going to be carrying out certain heads of expenditure under the terms of the lease, and if there is a cap on those expenses, the landlord needs to be comfortable that it can foot the bill for the rest of the costs, and that the cap is sufficient even with the annual increases to cover future likely costs. There are quite extensive provisions and negotiations that usually happen around a service charge regime and any excluded costs, and we can help advise in terms of both from a landlord and tenant perspective what you should be looking out for here, because it is a very complex area of law. So just to conclude and recap on why these heads of terms matter. So they really do help us as the lawyers draft the legal documents as quickly and as easily as possible. The less legal wrangling that we have to do typically means lower legal fees and a smoother and faster transaction. The heads of terms should be sufficiently detailed to prevent future arguments between the parties or any conflicts. They already provide evidence as to what the parties intended from the outset. Having a documented piece of paper literally provides the intention of the parties and avoiding protracted negotiations throughout the transaction. As we've mentioned before, we would definitely advise using an agent to negotiate the terms. They will know what is usual in the marketplace for similar buildings at that specific time and in that specific geographic area, and are best placed to advise. Although they are often drawn up by a commercial agent, you really should, either as a landlord or tenant, consider instructing a commercial property solicitor at the inception of the matter, and ideally seek legal input on the heads of terms. We here at Harrington Carmichael can advise on any terms which are uncommon in a lease of the specific nature. We can highlight to you any material terms which have been omitted and some points to consider that you may not otherwise have thought of, whether you are the landlord or the tenant. This will ensure that all potential issues have been identified and addressed prior to any detailed negotiations, and hopefully ensure a smoother outcome for both parties.
I think the point to note here, Hayley, is basically that it's worth a client often outlaying a couple of hours of legal time right at the outset of the transaction to get our advice on the heads of terms, to avoid complicated, expensive legal wrangling arguments, negotiations further on in the negotiations, or even during the lifespan of the lease.
Yeah, early prep and advice is definitely what we would recommend, and we are here to help. So on that note, you will find both Rachel and my details on this slide. our email address and direct contact number. If you want to contact us regarding anything that we have covered in this short session, then please do contact us after the session. Or of course, if you want to now raise any questions online or in the chat box, please do feel free to ask. And otherwise, if you want to contact us regarding a future lease transaction, being a landlord or tenant, you can do so. Just to also briefly mention, if you have any interest in taking space in our enterprise hub or have any questions regarding what we offer in the hub, then you can contact our email, which is hub@hc.law for any questions.
Thank you.
Thank you very much for listening.